Welcome to this audio edition of Beverly Hills Bar Association's 2024 Music Industry Legal Update. This presentation was recorded on August 23, 2024, during the first annual Entertainment Law Summit. In just a moment, you'll hear William Hochberg, Peter Anderson, Rami Yanni, and Jeff Biederman discuss cutting-edge issues in the music industry, from the impact of AI on copyright law to the complexities of live event ticketing and catalog sales.
The Music Industry Legal Update, put together by Bill Hochberg. Bill specializes in music and media law, representing top artists, estates, and companies. As a thought leader, Bill writes on music, business, and law topics in leading publications, including The Atlantic, Wired, and regularly in Forbes. And he speaks on industry-changing issues at South by Southwest and other key forums, including right here at the BHBA. Bill is a lifelong musician, and he's a board member of the New England Conservatory and New Music USA, helping create opportunities for great musicians. Bill, take it away.
Thanks so much, Jeff. So I want to introduce our panel here. We have Peter Anderson, one of the foremost copyright litigators anywhere. Peter's trial victory in the Stairway to Heaven case, where he represented Led Zepp's Plant and Page and Warner Chappell Music, really closed the floodgates that were opened by the Blurred Lines case a few years earlier, which encouraged really a river of sketchy demand letters and infringement lawsuits that many of you may have received if you're an entertainment or music attorney, from someone saying, hey, that song on the top 10, that's my song. And then you listen to the two and it's, hey, they both have a hi-hat and they both have crowd sounds. That's a ripoff. And a lot of those kinds of things were encouraged after the Blurred Lines case. Well, Peter kind of closed that. Okay, not completely, but quite effectively with his huge win in Stairway to Heaven lawsuit, and he represents many of the top recording artists and songwriters of all time, and also major music publishers and labels. In fact, he represents so many top artists and labels that he's not going to be able to speak today, actually. He will just be up here as eye candy, but you can judge by his facial expressions what his views are on these different issues. But joking aside, Peter will give us some great takeaways for all of you, whether you're transactional or litigators. Great takeaways today from his insights about what's going on today and what's going on tomorrow, what likely will happen tomorrow in the copyright litigation world. Then we have Rami Yanni, who's my partner at Rains Feldman Luttrell. Is a terrific intellectual property and entertainment attorney, also teaches at the USC Gould School of Law. And he also happens to be a badass bass player who's played at Madison Square Garden. I mean, serious bass player. Actually, he and I play in a group together. We do 60s and 70s TV themes, and we play at events like the San Fernando Valley Bar Association's Judges Gala. A really wild and crazy event, I can tell you. And, for $100 we'll play. For $200 we won't play. That's an old Groucho Marx line. But it's great to have him on here. And thank you. And he'll be also talking, among the things we're going to talk about, there's so many things to talk about. We could talk about each one of them for at least an hour, but we're going to try to really hit on the core essential things so you have a takeaway on that. One of the things Rami will be talking about, which he has experience with, is walk-on music and political campaigns. And he represents a PRO, which he also can't name, but he will talk about the trends and what's going on. And there is a lot going on, isn't there, with walk-on music at campaigns. So that's one of our issues. And then we have Jeff Biederman, who's a terrific transactional attorney at Greenberg Traurig with lots of experience in, I mentioned Peter is at Davis Wright Tremaine. Jeff at Greenberg Traurig, tons of experience with music catalog acquisitions, and that certainly is a super important thing to talk about. Is it a bubble that's going to burst? Is it going to keep on growing? What's been going on in that area? And also we'll talk about how these copyright issues that we're talking about may definitely affect valuations, things like termination notices, that kind of thing. with Jeff Biederman, some of you might remember Don Biederman, his father. Don was a well-loved luminary in the music law world. He was general counsel for Warner Chappell for many years, and was a professor at most every great law school in the LA basin. We hope one of Jeff's kids will carry on the family tradition and become a great music attorney like Dad and Granddad.
Roll me tuition I'm paying. I'm praying for that too. That would be a blessing. Yeah.
So we're gonna talk about music AI. We're gonna talk about some key music copyright developments, very recent. Going to talk about the catalog marketplace if we have time, and we're going to try to talk about the rap lyrics, which has been a big issue. Rap lyrics in criminal and civil cases, and election campaign walk-on music. So getting started with the AI, I'd like to talk about the Suno and Udio cases, which are in the news right now. Those companies are being sued by the RIAA trade organization, as well as the trade organization for the major labels, as well as the major labels themselves, regarding their use of in their large learning models in of just about everything, all the music. And their defense, which just came out very recently, is that they liken their machines to a human musician who had played earlier songs to learn the building blocks of music, and then use what they had learned to create entirely new works in existing styles. So the question is, that I'll pose to you, to you, Peter, to start it, is it different? Is it different for an AI computer to listen to music than for a musician? Obviously, you're not going to sue a musician for listening to music and then using that to come up with something, as long as the output is not substantially similar. What do you think, Peter?
Well, it's a long-standing rule of copyright and it goes back, I think, to the video games, to the initial video games, that once you absorb something into a computer, the computer makes a copy, which is an unauthorized, either a licensed copy or an unauthorized copy. So what these companies tend to do is they're using copyrighted works to train their models. And some of them, like Suno, are very upfront about it. They say that we make copies of these sound recordings specifically to make music. So they take someone else's sound recordings of music and they make a copy internally to the model and train the model to create competing music. So as a first step, you've got that initial infringement. There's also the question of whether the output is infringing. And most of these companies are and there's like 15, 20 cases pending across the U.S. There was one that was actually supposed to start today in Delaware. It wasn't a music case, though, that the judge said he wanted to revisit the cross motions for summary judgment, so he stopped the trial. But what generally these people are saying, these companies are saying, is that the output isn't the same. The output isn't substantially similar, which may or may not be the case. As I understand it, I think UMG Recordings came up with some examples where the output was actually infringing, at least in their view. But the general argument is that the output isn't infringing, and the mere fact that we make a copy internally to train our models is a fair use. And that gets back to a fair use argument.
Let me get in on that. I mean, isn't it a fair use? I mean, is it any different than a musician? And in your brain, you're somewhere in your neurons and synapses, you have like a memory of a song. Is that copying? Why not sue everyone who remembers a song and starts whistling it?
Well, I think, first of all, there's a license. There's a license. If the person who's listening to the song on the radio, for example, there's a performance rights. There's it's licensed, and with the idea, either it's expressly or implicitly, that someone's going to hear it in their head. And, maybe they remember it, maybe they don't. Maybe they can, discern, certain chord progressions or something that they like. But when you've got a computer, it's making an exact copy internally. And, traditionally, as I said, and you mentioned this before, well, how's it different from what the human mind does? Maybe a court buys that argument. But as of right now, when you do this, you're making a copy internally in the computer, and that is an unauthorized use.
I mean, with a human listening to a song, and then somewhere it's in their gray matter physically. It's being stored in a fixed medium. That might somehow be an infringement, but what are the damages? There might be brain damage if it's a bad song. A bad song going around in your head could cause brain damage. What do you guys?
Okay, so I mentioned one other thing. There's other theories too. Just to round it out, some of these cases argue that the terms of use have been violated, where the content is posted by the copyright owner, that the terms of use are violated. There's a few cases that raise that it's a use of the play. It's not even a copyright claim. It's a voice and claim. So you can have a state law claim. But I just wanted to mention that.
Rami, what do you think?
So I think, and I agree with Peter's analysis, but I think using the brain example versus what's copied onto a computer, I think the distinction here is fixation. And when a piece of music or anything is copied into your brain, it doesn't fall within the definition of fixation as we understand it under the Copyright Act. And that's what distinguishes these AI models. They're actually making copies of whatever the content may be. And there's already some jurisprudence around text material. There's the Anderson versus Stability AI case, which recently had a ruling from Judge Orrick in the Northern District. And they're distinguishing, I'm distinguishing fixation, which is recognized under the Copyright Act, versus what you're saying, Bill, which is a very valid question. Well, if you record or remember a song in your mind and then use it to create new music, how is that distinguishable? And I think it doesn't fall within the fixation, and Peter, you can recite the act much better than I can, but it has to be fixed in a way that it can be perceived by others.
I would even go back to the Constitution, because the ability for Congress to issue copyright laws is limited to writings, and your brain isn't a writing. Technically, from an electronic standpoint, the internal memory of a computer is a writing. But, so maybe there's even a constitutional problem with that argument.
Could be, yeah. And you had talked about the Orrick case, which involves that's a comedy case, right? Sarah Silverman.
No, the Orrick case was Anderson, Sarah Anderson versus Stability AI. It was actual based on graphic images.
Oh, okay.
Yeah. But there is another case by Sarah Silverman, also against ChatGPT, that's pending, along with a few other.
You were also talking about something interesting about Getty Images, and this gets more into transactional issues. Can you talk about that?
Yeah. So the AI quandary dilemma that we're all facing right now, the courts are just starting to chip away at it. And as often is the case with new legal challenges, the market finds a solution. And we're already seeing some market solutions. I have not seen these, whether we're replicated in the music industry yet, but in the graphic image industry, Getty Images has now created its own AI engine called AI by Getty Images. Pretty novel branding. And in this, you can use Getty Images' universe of images that Getty owns the copyright to, and I think it's something like 700 million images, and use their AI tool, AI generator, to generate images, put in your prompt like you would with any other AI, and anything that comes out of that is protected because it's based on learning of it. All of the learning is based on a controlled universe. It's a universe of copyrighted work, all owned by Getty, and Getty has gone the extra step of saying that if you are sued for infringement based on the output of our Getty AI program, we will indemnify you from infringement.
Wow.
I have not seen this with music AI, and I was looking this up yesterday. I haven't found any. I think the analog here in music would be production music libraries, where you've got a universe of production music that's owned. Both the compositions and the masters are owned by the music library, and then that can be used and can be licensed. I haven't seen any libraries that have actually created an AI model that allows you to actually create music based on the music that exists in their library.
Yeah, I don't think that any of the music publishers or labels are going to be too eager to offer up their libraries for something like that. for among other things, because the artist wouldn't be absolutely thrilled with that idea. But with photographers, it would seem like the same thing. If you had a prompt that said, I wanted to be in the style of a famous photographer, that's a problem, isn't it?
Well, I mean, what you put into the AI prompt might generate something that looks like a particular photographer, but if all of the learning, all of the data that went into the learning of this AI algorithm is data owned by in this case, the copyright owner, Getty Images, there really is not a basis for infringement, I think.
Yeah. So, Jeff, one thing we know too about this is that you can't copyright AI music, right? That was a guidance from the Copyright Office, which then turned into
needs to create it.
Yeah, it can't be. There was one case cited by the Copyright Office about a case, Urantia Foundation, which involved, you know that one? It involved a guy who wrote a book, but he said he didn't write it. He was channeling a divine alien. Okay, and he writes this book. Somebody steals the book, or somebody takes the book and publishes it without authorization. He sues for copyright infringement, and the court is like, wait a minute. You said you didn't write it. You said it would bring the alien in here who has standing to sue.
You've got to love the Ninth Circuit. It actually has that case that says that that a divine person can't be an author under the Copyright Act, and there's another Ninth Circuit case that says that baboons cannot be because of that selfie by the baboon.
Oh, right.
Yeah, only the Ninth Circuit.
Yeah. So it's hard to monitor.
Years ago, I represented the Miles Davis estate for about 20 years. And I get a call that someone has built a Miles Cafe in the Times Square area of New York. So I run the owner down and I said, hey, you can't have a Miles Cafe with a Trump, right? He says to me, Miles spoke to me in my dreams. And changed my name to Miles Kobayashi, and I opened this thing. I said, well, tragically, Miles didn't explain to you the trademark. I was suing you Monday, it's stuff.
Dream turns into nightmare. That's amazing. In terms of, since you can't monetize copyrights, is there a way to make money? I mean, Suno and Udio and other companies obviously think there's some kind of market for music that cannot be copyrighted. Is there one, do you think?
Well, I guess the analogy would be when recordings have fallen into the PD. Again, a good Miles example. Some Miles's greatest works were done in the 50s, right? They're starting to fall into the PD in Europe, jazz is much more popular there than here. And what Sony has done is repackaged the original recordings, which are no longer protectable, with interviews and clips and unreleased material. So it's kind of window dressing, but the core, I don't think so. It was interesting. We didn't talk about this on our phone call, but I've been doing a lot of karaoke licensing weirdly lately, and then singing. And yes, well, you can play bass for me. In real time, I'm on the third draft of a license with Sony Music, and they're saying this is our new AI paragraph, where you have to put in protections so that their data will not be scrubbed from your karaoke service to facilitate machine learning.
Wow.
So it's real time change.
On the monetizing point, you're thinking of resales, but there's apps have value. I mean, even if the person just is able to say, they pay a fee and they're able to say, tonight I'd like to listen to something like Beyonce, and it just starts generating Beyonce songs. So there's value there, even if you can't, then resell it or anyone can copy it because there's no protection.
Or it's a tool for musicians. It could be a tool like for mastering or orchestration, things that some orchestrators might not love that. It's an art form too, and some mastering engineers might think that can't be done, but it is being done. And so AI is being used also for content ID to find infringements and things like that. So yeah, you've always had it as a threat to musicians, and it really goes back in history. I wrote an article in the Atlantic about 10 years ago called "When Robots Write Songs," and it's briefly, it's you used to have bands that were playing in lobbies of hotels in like Santa Monica and stuff, and then many years later the synthesizer came along, and all the horn players lost their gig, and it was a synthesizer player, right? And then a bass player, and then and the bass players lost their gig. The synth player and maybe a singer, and then along came the DJs, and so the synth player lost their gig and were screaming bloody murder because now they don't need that. And now the DJ is losing the gig because it's AI, and they're screaming bloody murder, and they're saying, wait a minute, like the DJ who sits behind the console and hits the play button is, no, there's much more to it. You got to read the room. And how can a robot read a room? No, there's no way that, that can happen. If anybody remembers that Saturday Night Live sketch with Andy Samberg of Lonely Island, called When the Bass Drops, where you have a DJ who's sort of like Avicii and a big packed club, and he's sitting there behind, he's like doing fist pumps and he's moving his head around, and then the camera goes back and you see what he's doing behind there. He's got like a model train set. He's frying an egg. He's playing solitaire. So musicians have been progressively getting it bad, but thankfully, I would think that this trend is back toward live music. Wouldn't you say that as well? So AI will never create great music. And one reason is because it can't cry. AI doesn't cry. John Lennon lost his mother tragically just a few years before the Beatles started in a freak car accident. You had Leonard Cohen, banging his head against the floor in the Chelsea Hotel. Computers don't do that. So I don't think they come up with great music. What do you think?
Some writers are using it for writer's block. I was looking for that.
Really?
Yeah, it was really, if I can dig it out, I'll see if I can find it.
Yeah.
But yeah, it's interesting.
Well, so it's interesting because AI is being used as a tool in many industries, including the legal industry. But what some music libraries are doing now is they're using AI as a search tool. So you can use common language prompts to simply describe. This is particularly for production music, film, television, video games. You can just put in a basic sentence, English sentence, describing the scene. Dark, rainy, alley, etc. And they will deliver music that's suitable to that particular scene, just as described. That's something that music libraries are benefiting from with AI, which is different from using AI to actually generate the music. It's a what I'd call an advanced search tool.
Great. So when we're talking about music copyright, we're usually talking either about infringement, termination rights, that kind of thing. There's a recent case that the Supreme Court came out with, Warner Chappell v. Neely. And Peter, maybe you could talk a bit about that case and what the takeaway is for people here. That's a case where, if I can set the table on that, it's a guy who was in prison in Florida found out that Flo Rida, the rapper, had used his song in an interpolation, but he didn't find out about it in the prison because they didn't have the greatest internet in the prison. In fact, they had no internet in the prison. But he finds out about it later. He sues Warner Chappell and others, and they have a statute of limitations, and I guess still latches, or unless latches is completely out of it. But maybe you could give us your hot take on that.
It's sort of fallout, and it doesn't answer the questions really, but it's sort of fallout from Petrella, which in the Supreme Court in 2014 said that latches didn't apply to copyright infringement claims. But in Ginsburg's opinion, she also had references to that it's a 3-year statute. After that, there's no liability. And there's a footnote that referred to the fact that some circuits apply a delayed discovery rule to copyright infringement cases. And so the fallout from that initially was, okay, does that mean delayed discovery no longer applies? We've got clear language in the body of the opinion that says it's 3 years and you're out. And then we've got this reference, and the court didn't say anything like, we're not going to decide that issue. So what happened in the Second Circuit was they came up with this rule that, look, 3 years and you're out. That's what the Supreme Court said. But we still have delayed discovery. So you can sue for an infringement that you just learned about that happened 10 years earlier, but you can't get any damages for it, which doesn't make a whole lot of sense, because why would you sue over something 10 years ago if you can't get any relief? The Ninth Circuit said, basically, it doesn't make any sense. And in Stars Entertainment said, no, the Petrella decision has nothing to do with delayed discovery. So at that point, what you have is some circuits don't allow delayed discovery. The Second Circuit says it's a partial bar. It doesn't if you have delayed discovery, you can sue for liability, but you can't get damages. And the Ninth Circuit said nothing's changed. And so Warner Chappell versus Neely, Warner really wanted the court to rule on whether or not you could have the delayed discovery rule. But in the lower court, they were in a circuit that allowed the delayed discovery rule and no one challenged it. So when it got to the Supreme Court, 6 of the justices said, we're just going to assume delayed discovery applies. We're not going to rule on whether it applies. We're just going to assume because everyone assumed in the lower courts it applied. But this idea that it cuts off remedies makes no sense. So it rejected the Second Circuit opinion. The dissent said, basically 3 justices said, we should decide whether or not the delayed discovery is even available because it certainly seems like it isn't. So you've got at least 3 judges who don't like the delayed discovery rule. And it's anyone's guess whether there's 2 more of the remaining 6 that would do it. But they've basically punted it down the road. So at this point, we know that the Second Circuit attempt at trying to reconcile Petrella just didn't work. We're back to delayed discovery, and those circuits were allowed delayed discovery, and everyone's waiting for another case to go up to the Supreme Court to see whether or not that applies.
So, speaking of delayed discovery, in your Stairway to Heaven case, that's like 40 years ago, right? That this band, Spirit, was opening for Led Zeppelin, and they had a song that had an A minor with a descending bass line, and Stairway to Heaven has the same thing, and so does Music by Bach, by the way. So it's like we're all standing on the shoulders of giants. That was originally ascribed to Isaac Newton, and then someone said, no, he stole that from a French cleric 500 years earlier. But 40 years ago, and it's because we have this idea of currently in practice, a rolling statute of limitations as to copy. It's a 3-year statute, but it rolls. So like if you have a new box set, in the case of the Led Zeppelin case, was that a new box set? Can we ask a little bit about how you can go back 40 years?
Well, I mean, first of all, Stairway to Heaven wasn't a delayed discovery case because no one could dispute that they about the Stairway to Heaven.
Well, if it was in Florida, but no.
What they did was they sued for alleged profits within 3 years preceding the date they filed, which included the release of remastered recordings. But what that case did point up was the problem of getting rid of latches, because we're dealing with the access issue, and Ginsburg and Petrella said, look, copyright cases are simple. Are they substantially similar? What she left out was you have to prove copying. And so you're faced with, what was the access facts, in 1969, 1970, witnesses have died, set lists have disappeared. People are saying, well, Robert Plant was at a bar that had, Spirit playing in the background, but we don't know if Spirit played that song. And so all those issues would normally have raised a laches defense, and for good reason. The plaintiff, actually the original songwriter, but then the trustee knew about Stairway to Heaven for 40 years, did nothing about it, and witnesses passed, documents were lost, memories faded, but we couldn't raise latches. So,
anybody else on that before we go to the Vedder v. Resnick case, which is really wild? Okay. So there's another very recent case, but it's not the U.S. Supreme Court. It's the District Court of Middle District of Louisiana in Baton Rouge, where you have Judge Shelley Dick ruling that denying a motion to dismiss. Well, what happened there is you have somebody contending that this song, not that well-known a song, it's been covered by some people, but that the termination right, nobody disputes that there is a termination right, but that we all know, anyone who knows about and works with termination rights knows that what is written in stone is that it only applies within the borders of the United States. And in the rest of the world, everything remains. Well, this judge said, why is that? The judge said it's plausible. She didn't rule on it, because she just said it's plausible and denied the motion to dismiss. And we'll see how that plays out. But the judge had an argument. It was quite a lengthy opinion. I thought it was well written, but you probably disagree with a lot of it. But why is it that it shouldn't? I mean, and she distinguished, or she said the plaintiff distinguished credibly that there's two things that you look at: ownership and conduct. And she said the conduct, yeah, you would go to the country where the conduct is happening and apply the law there. But the ownership issue, you would only use a U.S. law. And that would be a nightmare for all the content companies if people could terminate the copyright worldwide. What happens now is that you threaten to terminate, the kind of playbook plays that you threaten to terminate U.S. rights on, say, a major publishing deal or something. And then they go, well, they politely remind you that, well, it's only for the U.S. We've got the rest of the world. And they do-si-do and do a little dance. And then it's like, let's work out a better deal. So that's the playbook play. But if that case down in Baton Rouge became the law, it would be like, I want my copyright back. Thank you very much. And what do you think? Is there any possibility that case could be the law of the land? And, and that certainly would, Jeff, that would affect your catalog sales quite a bit.
Sure. Yeah.
Well, there's actually another issue. There are two things that were undisputed. They had an Abed situation. The author had granted rights in the renewal term, didn't survive to renew, and so it was undisputed that the successor, the statutory successor, got that renewal copyright free and clear of prior grants. And the court determined it was plausible that recovered renewal copyright extended overseas, which is an issue that has been out there for years. There's good arguments, I think good arguments that that's correct. But the really challenging part of the opinion is what Bill described, where the court went on to say that the statutory termination, which whether you're talking about 203 or 304C, specifically says that termination does not terminate any rights under foreign law and only terminates rights under the Title 17. And what the court did in Louisiana was it said, well, the rights, but actually, let me step back. Rights in foreign territories are governed by the Berne Convention. The Berne Convention, each nation says, we'll give you our copyright protection that you would get if you were a citizen, if you're a member. What the court did was it looked at it differently and it said, no, there's only one copyright, a U.S. copyright that is enforced outside the U.S. And since there's only one copyright, it's the U.S. copyright. It arises under the U.S. Copyright Act, so it's not a copyright that arises under foreign law. Which, first of all, if you do that, then the whole exception, rights under foreign law, aren't affected, has no meaning, because termination by definition only applies to grants of copyrights. And if all copyrights of U.S. works are just U.S. copyrights and don't arise under foreign law, then there's no reason to go on and say, and it doesn't affect rights under foreign law. So it makes no sense. The statute, I think, is absolutely clear. I have never heard anyone make that argument before. And it's definitely not the accepted interpretation of it, and the language seems clear.
No, and so, Jeff, I mean, like, even without that, which would just be a huge quantum leap from what we have today. What we have today is still a problem. Like, you have a James Brown catalog sells to primary wave, and then you have termination notices coming up from the heirs and different sets of heirs making different, competing. But what a mess. So how do these termination rights come into your life as you do a lot of catalog work? Do you in the analysis, and what's your thoughts on that?
Well, we talked about that amongst ourselves. I don't know anybody who buys a gotcha, buys the lottery ticket, like maybe they can sue somebody. No, my label clients would love that. But it doesn't make any sense to me either. We've all built our valuation models and our practices on the accepted rule that it only, it stayed at the ocean's board. That makes no sense to me at all.
Yeah,
it's crazy.
But that, and also the AI stuff we were talking about before, all of that factors into the transactional world when you're doing a deal, right? I mean,
right. But we were talking about this yesterday. We were on it wasn't one of these crazy huge deals, but it was a substantial catalog sale, and the valuator, a pretty experienced evaluator, hadn't taken termination rights into effect in their evaluation of the price of the catalog, which seemed, again, as a practitioner, nuts. how do you evaluate what the price of something if you're not factoring in that an income stream may end in 3 or 4 years?
Yeah.
Right. The age of the catalog is critical.
Yeah. Let me also ask the audience, how many of you are litigators who litigate in the music world to some extent? I know you are, Neville. That's for sure. And what about transactional attorneys that work in music? A few. But there are a lot of you that we really don't want to lose track here of what we're talking. We want you to understand what we're talking about generally. So this termination right under the U.S. Copyright Act really is an odd beast, but it's just so great for heirs, say old copyrights, and the authors themselves, where they just get, regardless, notwithstanding agreements to the contrary, which means no matter what the idea behind it is that the authors typically sign really crappy deals when they're young and they sign something off, and then later on they may have a catalog that's really worth a lot, but they sold it, and the idea is to give their heirs a second bite at the apple, 56 years or 75 years under for stuff that was published before 78, and it's 35 years for agreements that were entered into after 78. But anyway, it's a second bite of the apple. It's a generous congressional gift to the authors and their heirs. And it's not only to be a gift, it's the basic premise behind it is to espouse more creativity for society. So it's supposed to help society by making it easier to be a creative, to give you an incentive to create music or whatever other works you do. So, but you have a situation like Jeff is talking about where you're selling a catalog that really has become very valuable. And, but then you have the possibility that there's going to be something coming out of the woodwork in the form of a termination notice.
Resnick will not help the value of catalogs in that stance.
Yeah, and while you're talking about music catalogs, just to be clear, this applies across the board. So if you've got a client who did a book, or you represent the movie studio, and the movie studio does a movie version of the book, a notice of termination comes across. Usually what happens is, at least what I've heard, is that the studio says your rights are limited to the U.S., our rights are foreign. You can't get anyone to fund a new movie based on your book if the rights are limited to the U.S., so let's work together, and that usually happens. Under this case in Louisiana, basically, the studio would lose rights around the world. It's just crazy.
Yeah, and yet catalog sales are booming still. I mean, that's a question for you. Are they really booming? I mean, we have seen that streaming may have, some argue that it may have reached a peak. Others say no, it's got a long ways to go. It's like a 6% growth, 7% growth rate, where people were expecting the last report to be about 10 or 12%.
It's still, and people's not as high.
And Universal's stock one day in July dropped quarterly earnings by like 24%. Now it's come back quite a bit. I think largely because of that disappointment over streaming. So, notwithstanding all that, we have like these eye-popping deals that just keep getting bigger and bigger. Dylan, 500 million, Springsteen, 500 million. And then you're like, well, okay, we're not going to see that again. And then Queen, £1 billion. So it's like $1.2 million. What's next? Is this going to continue, or have we kind of reached a top there?
Well, we were talking about this a little bit amongst the four of us. I haven't seen the prices dramatically drop. I would say it's plateaued a little bit, but the strong catalog still get good prices. The analogy would be if you are trying to sell your home in a softening real estate market, if you price it, well, I say it this way. In a hot real estate market, if you price your house correctly, you can get 2 or 3 full price offers that first day or the first couple of days, right? In a softening market, you may still get the price that you want, but it's going to be a 3, 4, 5, 6 week nail biter trying to get to where you want to be. That's what I'm seeing. So I'm not seeing a dramatic drop in prices for sure. And I should say I sit on both sides of this, so half of me smiling, half of me crying. But it's just taking a lot longer to find a home. The price of money is higher. I think what's happening, this is really more in Peter Rami's, what happened with Merck. He was the market maker for a very long time, so I hope we'll touch on that too. But there's a bunch of things that are kind of cooling people's jets a little bit, so the market is still People are paying top dollar. But I would say when I'm on the sell side, I do a little more homework. It takes me a little bit longer to find a catalog at home.
So he's talking about Mercuriadis, who founded a company called Hypnosis, which was really the pioneering company in these eye-popping acquisitions. And he got the name Hypnosis from another company started by a graphic artist named Storm Thurman, Thurgeson or something, Storm something, who actually created the logo for Led Zeppelin, among many other things. Presumably he has a license to use the name Hypnosis. But the company was wildly successful, and then it turned out that there were a lot of other companies that jumped in there, and you have Apollo, with Harborview, and you've got Primary Wave.
Apollo with Concert?
Sony is buying up a lot of stuff. What?
The Concorde deal with Apollo was massive. We do a lot of ABS, asset-backed securities. That to your earlier question, I think part of what's keeping the prices elevated is that non-music money is chasing music assets. It's something that folks on Wall Street really get because the copyright is essentially an annuity. So you got Concorde and endless banks I should mention that we work with that are now investing in copyrights, mostly music, but also some video when it's possible.
But then you have copyrights that they're not an annuity forever. It's not like you buy real estate and you can own it forever. I mean, it's got a life term, right? 95 years.
Yeah.
And
to the veteran.
Unless it's so even under any circumstances. So if Dylan is selling his catalog of hits in the mid 1960s, by the early 2060s, it's in the public domain. So he's got maybe 30 years. And he sells it for maybe close to 30% multiple or something like that.
But sometimes the catalogs will also include name, image, and likeness rights, which if you protect those, can have a much longer lifespan.
But name and likeness
trade rights, essentially, right?
Rami, don't even have a statute. Well, there would be a statute of limitations, I guess, or latches.
Name can go on in perpetuity, but in terms of the publicity rights, there's a limit to postmortem right, depending on state. Some states don't even have a postmortem right of publicity, but many states, I think California's postmortem right of publicity is 50 years, if I'm not mistaken.
Mm-hmm.
I could be off 10 or 20 years on that. But yeah, so that does have a limit. But I'm curious in this question for Jeff, these staggering numbers, these $500 million or $1 billion acquisitions, what do you think these investors are looking at in terms of a timeline for return on investment?
That's a very good question. Again, on that side, the evaluators, whether it's FTI or I guess Virtu is now the group left. It seems that, to your termination, right? How do you calculate an ROI if you don't know how long the stream's coming in? Right. And obviously, if the territories disappear, that will not help sales at all. But to your name, image, and likeness issue, it seems like that's going like crazy, right? We're talking about a federal, I think Tennessee within the last 3 weeks to have the Elvis Act to protect name, image, likeness from AI. So we'll see how that. I guess there's probably not a case on that yet, but we'll see.
Is there any other recent developments in that area regarding legislation around like the Elvis Act? We were talking about that the other day. Oops. Oh, hey. Oh, Siri has an answer. Okay. That's, I didn't ask Siri.
Hey, I can finish it on.
Siri always has terrible answers, but okay. We'll just let you Siri finish this one. I'll turn that off. But yeah,
Just stop here.
Oh, I swear you can't make this stuff up.
The next panel, you should have Siri.
Stop, Siri.
Just stop here.
Okay. All right. Create a song Siri, create me a life-changing song. Nothing. Okay. Siri turned off. Okay. Yeah. So, AI and copyright, are they a downer for the market value of some of these catalogs, or are they actually something that could be helpful? It's a double-edged sword, right? If you buy a catalog, on the one hand, you don't want to get sued for it. On the other hand, you might want to sue other people for infringing stuff that's in there. So it's sort of like you're playing it both ways. What do you think?
I think that's absolutely right. I mean, if you're a record company or a music publisher that is their works are being infringed, you'd like to go back, to the beginning of time, But if you're the same company's being sued, you'd like any liability to be cut off after 3 years, or the ability to use latches. So it's a double-edged sword. It depends on which hat you're wearing. Are you the plaintiff or the defendant?
So do you think, is your forecast, Jeff, that the values are going to continue? And do the interest rates also factor into the value? Or how so?
The cost of money. Well, the deals, the prices they're laying out, because a lot of it's with borrowed cash. Certainly you would think, but I remember having lunch with a publishing company president, got to be nigh on a decade ago now, and two companies were chasing a catalog of ours, and he made a pitch. I listened respectfully, and I said, well, we're probably going to go with company B. And huffily he says, well, go ahead. He said, you'll be begging me for deals. This is all going to die in 18 months. Well, it's still, but mathematically, right? It's a zero-sum game. Somebody's paying more, for you to get more. I don't know when it's going to end. I mean, thank God, because back to my intro, I have a lot of tuition coming down the pipe. So that's beautiful. But it can't last forever, right?
Okay. Let's pivot a little bit, but stay on this, but to rap and hip hop. And are you seeing the sales of those catalogs being the same? I mean, does that hold up the same way as, say, legacy classic rock catalogs and things like that?
I don't think anything does as well. Motown is the gold standard, right? Because everyone loves it, and then it's used in every movie, every film, every advertisement, down to, I sold a Christian music catalog a few years ago, and it was like a 2.8 multiple, and the client took it because you can't sell paper towels in front of Jesus, right? Yeah, it really depends on the spectrum, but hip hop is still the most popular kind of music. It's just a question outside of the subscriber play, where else can you monetize it? And to me, again, Motown or the Beach Boys or the Beatles, right? Those are the things that's evergreen.
Okay, and then there's one other issue, which is the rap lyrics, and this has been a big issue within the last year about rap lyrics being used in trials. So we had like two trials, one that's still going on. In fact, it's quite a long RICO trial in Georgia for Young Thug. Took a year to pick a jury. And it's Fonnie Willis is the prosecutor there, and it's a case where they're claiming that Young Thug is the leader of a gang that's connected with the Bloods, and that he is using his raps are actually like recruitment methods. That some of the things in there say like, I'm a general in this rap army, things like that. It turns out the judge Ural Granville is a in the Army Reserve. He is a general, and he read the lyrics to the jury during the jury impanelment, and one of the lyrics that he read to the jury is "fuck the judge," which was interesting. But in any event,
Real bridge builder.
Huh? Yeah,
real bridge builder.
So, but the person who's running against Fonnie Willis, district attorney, is a Republican who vows to have that case dismissed, have that case thrown out. And it's going on, but it's a case about should rap lyrics be used as evidence in any circumstance, and Judge Ural Granville allowed it to be used conditionally, but with restrictions. I mean, it can't be the only evidence. It has to be specific as to some particular crime with some evidence like that. Meanwhile, so he's allowing it in, and actually he's now no longer in the case. They found a reason to remove him from the case. Very tricky case down there. It's a RICO case in Georgia. Then you go up to Brooklyn, and you had the Run DMC Grandmaster Jam Master Jay trial. He was actually in his recording studio. A guy came in and shot him in the head, and it turned out the guy was his godson. But anyway, it was a bad actor. He actually did a rap saying, we should call headshot or something like that. And it's like we shoot him in the head and then we wait and watch him drop. And that's exactly what witnesses said he did. And the judge, it was in district court in Brooklyn, the Eastern District of New York, wouldn't allow that in, or a video of him dancing in front of a mural of Jam Master Jay bragging about things he did, wouldn't allow it in. And one of the things that the judge, LaShawn Darcy Hall, said was, he may have, about the shot in the head, he may, maybe he shot a lot of people in the head, but we don't have any evidence that it was this guy that he shot in the head, wouldn't allow it in. But in that case, there's a lot of other evidence, and they convicted this guy. But they wouldn't allow the rap lyrics in, and she wrote a really, really beautiful opinion, actually, that talked about the history of rap, actually, and how the exaggerations and things are, it's like the public demands it, and it's part of that thing, and it's not to be used unless it's very specific, and it's not enough to say. So very recently, Drake released a rap very recently that actually has Young Thug in it, and it's I think it's an old recording, but even before, and in that Drake has a rap that says something about I get blood money or something like that, and he talks about it, and almost like thumbing his nose at the court, like sort of admitting that he's got some, the way I read it, maybe he's got some connection to the Bloods, but anyway, that case wouldn't allow the lyrics in, or the video, and they convicted him. And then down in Georgia, you really don't have much evidence. You have a manager who was shot to death outside in Georgia, outside of a barber shop. There was a drive-by shooting, and they traced the car rental to Young Thug. And there's not a whole lot more than that. They're really leaning on the lyrics. And they say that the lyrics are specific enough. What do you guys think? I mean, it's sort of character evidence. Should it be allowed in? Any thoughts on that?
Well, you generally can't use, I don't know what the Georgia rules and evidence are, or New York, but as a general proposition, and definitely in federal court, there's strict limitations on character evidence. And my understanding in both cases is that it's not being used for character evidence, but it's being used to try and prove an element in the crime. And in Brooklyn, I think you identified the distinctions. In Brooklyn, the allegation was that they had shot Mizell, and there was nothing in the lyrics that actually supported that. And also there was this point that, look, if you just look to the lyrics, it's not really probative of anything because it's artistic expression. You make all kinds of exaggerated claims. And then also the suggestion that if you allow this, then there's a racial element, that you're basically, tainting them with this music. And I mean, no one thinks that, Neil Young actually shot his baby down by the river. He said that, but, so people say things in lyrics, and that makes sense. In the Georgia case, it's the Georgia RICO Act, which they have to prove something different. They have to prove that there was this organization and collaborative behavior, and the songs the judge found, I think there were 17 different lyrics that supposedly supported the idea that there was, some organization to it.
Right.
And also, by the way, it just, last night, I didn't even realize this. In 2017, there was a case in California that allowed the use of rap lyrics in a criminal case. And then California passed the decriminalization of artistic expression or something. They amended the evidence code to place specific limitations on the ability to use rap or any artistic expression. It has to do things like, identify details that aren't publicly known, details about the crime that aren't publicly known, or it has to, really be specific to that kind of that alleged crime. And there's the ability to show that, no, this is, a creative element. There's, by statute, you can come in with experts to talk about that. You can talk about, and you have to consider, the court has to consider any racial prejudice that might result from it. So California acted to actually kind of, limit that. So that I would think that the only kind of rap lyrics or any lyrics that you could really rely on, would have to be basically a confession. The kind of thing that happened for the billionaire who admitted,
Right.
With the mic on, I killed him. It has to be something like that.
Yeah. There's another statute in New York, and there's been attempts to have a federal statute that haven't passed. But yeah, you have lots of lyrics. You got, I shot a man in Reno. You got from Johnny Cash. You've got I Shot the Sheriff, Marley. You've got Mac the Knife. Very violent, super gory, violent stuff. Sinatra. And you have Mick Jagger, Midnight Rambler. Really, if you listen to those lyrics, they're pretty gross. But Mick Jagger was knighted at Buckingham Palace, so he's Sir Mick Jagger, and Young Thug is languishing in Fulton County Jail. So not that that's, I'm not saying there's anything to that. I mean, but you have that, the public likes violent entertainment and lyrics. I mean, that's just the fact. And that's something that Judge Darcy Hall talks about in her decision. But and then you have that going on. What else is in the news is the beef between Kendrick and Drake. And one question I would put to the panel is would it be wise for one of them to file a defamation claim against the other one? Any thoughts on that?
I mean, look, the standard for defamation is so high, and the lyric I saw, the two lyrics I saw, there may be others, were really sort of just opinion, I think. But it got some press, and I don't know if it's even real, but the idea of actually suing over someone else's lyrics seems a little bit.
But also Discovery.
I don't know what the damage is.
Yeah, what would Discovery look like getting into people's business?
Yeah.
Not another reason not to sue in that. But
didn't Drake use AI in that beef? I think he did AI creative versions of Snoop Dogg and somebody else. Sort of ironic,
right?
Yeah.
What's that? They did. Yeah. But is hip hop? Do you see a lot of catalog sales that are as big as the other ones yet, or will that happen later? Hip hop catalog?
I think it'll come later, but sure, it's still the most popular genre of music, I think.
Yeah. So I think we're going to talk now about something that everybody is paying attention to, which is the elections, and you have candidates walking out to the podium and they have their walk-on music like baseball players, and they have walk-off music too. And in the case you have Trump, who I would let, Rami's going to talk about this, I would suspect doesn't have a lot of permission. And then Kamala, who we know that she's getting endorsements and she's palling around with a lot of big musicians and she's playing their music when she comes out. Some people don't want to get political. I mean, there's some artists that don't want to get near that. Like, Hold On, I'm Coming. Isn't that Sam and Dave?
That's Isaac Hayes' composition.
Yeah, he's Sam and Dave. Yeah, okay, right. Yeah, but I think that was something that even though they wrote a letter, even if that was back in Obama days, they supported him, but they said, please don't play that when you're going up, because I've got a lot of fans that are on the right, and I don't want to get political here. But Rami, take it away on what's going on.
Yeah, so if you look, I started doing a little research by just simply doing a Google search for musicians who oppose Donald Trump's use of their music. It's just for the fun of it. This is not to be biased towards one side or the other. And I got 1, 2, 3, 4, 5 pages of results. And I did, in fairness, make a similar prompt with respect to Kamala Harris and Biden, and did not come up with anything. Don't ask me why. Maybe Google is biased in its results, but there is a long list of artists whose music has been used for intro and outro, as they call it, walk-off music, by the Donald Trump campaign and also by the RNC. That's been the majority of jurisprudence we found, the most recent being the Isaac Hayes estate suing just last Friday the Trump campaign for use of the song that you just mentioned, Hold On, I'm Coming. Isaac Hayes was one of 2 composers and ended up being his estate now is the sole owner of copyright in the composition, and it was being used by the Trump campaign for some period of time. And after ignoring demand letters from the Isaac Hayes estate,
They sued for $3 million, citing 150 uses, so 150 infringements of that song. Now, interestingly, we have the performance rights issue. A lot of campaign events take place at venues that have blanket licenses. So they may be stadiums, arenas, etc. They have blanket licenses with the PROs, BMI, ASCAP, GMR, and that was the case for Donald Trump. In this Isaac Hayes case, Isaac Hayes and the co-composer both were composers signed with BMI. And BMI, unlike other PROs, BMI actually grants blanket licenses to political campaigns. I understand that GMR, Global Music Rights, does not grant blanket licenses to political campaigns, although they do, of course, grant blanket licenses to venues like stadiums. A lot of these campaign events take place in locations like airplane hangars. Airplane hangars do not have blanket licenses for use of music, so they will need to get an actual blanket license from the PRO for the particular political campaign. In the case of BMI, their license includes an exclusionary right. That's a right to pull music out of the license if it's objected to by the composer who signed with that particular PRO. We don't have any evidence that was the case, whether or not the Isaac Hayes estate actually challenged that use of the song in the Trump campaign, but they do have the ability to pull that back. I understand other PROs like Global Music Rights actually have as a standard rule in all of their blanket licenses, not just campaign-specific blanket licenses, which, as I said, GMR does not grant, but blanket licenses to venues like stadiums, arenas, concert halls. They have in their blanket licenses the ability to exclude certain songs depending on the event. And I understand as a general rule, they do not allow use of their songs. This is, again, Global Music Rights. They don't allow use of their material for any political events, political campaigns, or for tribute bands. They do not like tribute bands using their music in concert. So that's just an aside. Anyway, I can go on. Celine Dion, Beyonce.
Before you go, and I want to hear that, but just to set the table just a bit on that, the blanket license is a nice blanket that you can put around yourself. It's basically saying that the entire catalog, and there's just, what is it, 1 billion songs between ASCAP, all your money, something like that you can use these, but you can only use the audio, and it's only at, it's at this venue live, so you cannot record it. So if you record it, you need another license called a sync license or a synchronization license to synchronize the music with the moving images. Now, Trump does a tricky thing, and others as well, which is that they will go into a venue that has the blanket license, and they will say, well, we're not recording it, but guess what? There's billions of people watching it on TV, and it's being archived, but we're not doing it. It's NBC and CNN and MSNBC and Fox that are doing it. So is there any kind of liability there, do you think, anyone, about, like, if you're Trump or anyone? Elizabeth Warren, I think, also got a takedown for back when she was running for using music, and you're at a venue, it's got a blanket license, for a live event only. It's not for taping, but yet everybody in the world is watching it. It's being taped forever. It's going to be on the internet forever. It's archived and all that. But I didn't do it. It was the news media that did it.
Well, maybe you three may know the answer. I don't. But if you have a blanket license and it's going, you're going to record that specific performance to issue a live album, do you have to get some special permission, or do the blanket licenses cover that?
And I think the answer is you need a mechanical license.
Yeah, right. So then why wouldn't that apply if you're not recording it, but ABC is? And so there might be some, contributory or vicarious liability theory that would make the politician liable for what ABC or CBS does. The other thing I want to mention, just to be clear, you've got 4 or 5 pages. Each one has like 8 entries. So we're not talking about claims. Yeah, we're talking about 50 or so.
4 or 5 pages. Each page has like 10 different lotteries. Yeah, it's a whole thing.
So, question for Rami, actually.
Yes.
So we sent one of the years of, 2 or 3 campaigns ago, because it wasn't a one-off, but the candidate was making it his walk-off song. So we made a Lanham Act, goodwill, stealing of goodwill kind of argument, because he was making it his trademark, not little t trademark, to walk off to this one song. My client hated him. So that was our argument, because it wasn't filmed. We didn't have a sync hook to get him with, but we said, hey, you're trading on our goodwill.
Actually, that's an excellent point. I was actually going to mention that part of the Isaac Hayes, I'm using the Isaac Hayes estate simply because the lawsuit was just filed last Friday. There have been other lawsuits. 2020, Neil Young sued the Trump estate for using Rockin' in the Free World. There have been others. But in the Isaac Hayes lawsuit, they did also include a Lanham Act false endorsement claim, claiming that the use of the song, why am I blanking on the song name now? The Sam and Dave song.
Hold on, I'm coming.
Yeah, Hold On, I'm Coming. Thank you. The use of the song as, I think it's the outro, is creating an association in the minds of consumers that there is some affiliation, sponsorship, or endorsement by the Isaac Hayes estate of the Trump campaign. So that is part of the claim. They also included a state right of publicity claim, claiming that they're by using the voice sorry, not the voice, because he's not singing on it, but by using the compositions that are so closely associated with Isaac Hayes, that they are invoking Isaac Hayes' likeness, and they're violating his right of publicity.
So I'm not sure if it's Sam and Dave. Maybe somebody can correct me out there, but it was Isaac Hayes, in the case of that song, was co-writer with someone else.
Yes.
David Preston or something, I think it was. And Isaac Hayes sold, or his estate sold to Primary Wave.
David Porter.
Yep. Okay. Sold the rights to Primary Wave, but and Primary Wave didn't, for the same reasons, I guess, as I've mentioned before, didn't want to get into this because it's a political issue, and right now we have a 50-50 sort of situation.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.